Morning, Your Honors, and may it please the Court. Kendall Stivers-Jones from the Appellate Division.
You may hear an echo there. We don't hear it. So you can, if you can, just ignore it.
Kendall Stivers-Jones from the Appellate Division of the Public Defender's Conference on behalf of the appellant, Mr. Quinton Perry. With the Court's permission, I'd like to reserve 7 minutes for rebuttal. Thank you, Chief Justice Page. So the case before Your Honors today has the unique ability to provide trial courts and appellate courts with guidance that has been lacking largely since the enactment of this particular portion of the sentencing statute in 1989. This particular portion is consecutive sentencing, and specifically permissive consecutive sentencing. It's not an issue of mandatory consecutive sentencing. And in Mr. Perry's case, it's the issue of whether or not an individual has a record of criminal behavior or criminal conviction that is considered extensive. The narrow issue in Mr. Perry's case is a combination of some very unique factors before this court. One, the fact that the unit of prosecution on the statute under which he was charged allows the state to indict for each piece of material, each piece of exploitative material under the sexual exploitation of a minor statute. So in Mr. Perry's case, he had 174 images, and there was the capacity to be charged 174 times. The second portion of that is that these were downloaded images. These were images that were uploaded to a cloud-based storage called Dropbox, which some of the court may be familiar with. So this case has the capacity for all of these images to become 174 convictions for one upload act. Or in his case, it's the elements of the offense also included sharing or trading with others.
Ms. Jones, is the
Yes.
record clear, or what does the record say with regard to the time period over which he downloaded these?
That's the third factor that brings into this. The state at trial, largely put zero proof on after Mr. Perry confessed. There is proof in the record, in the sentencing, in the pre-sentence report, that these acts occurred in 2016 and 2017. So Mr. Perry has enough in the record, there's enough in the record to establish that Mr. Perry traded or exchanged these twice. Now, that's compounded by the fact that these are downloaded images or uploaded images, because as the court may be familiar, if you download an album, if you download Rolling Stones 40 Licks, you're getting 40 different files all at the same time with one particular download. And that's the state could have put that proof on, but it didn't.
Why does that matter? I mean, why does it matter if it was 1 click or 5 clicks?
It matters
For purposes of determining whether this is extensive.
So there are two different considerations here, and one is the fact that sentencing is a different animal in terms of determining what is extensive than what the legislator decide to allow or afford the state in terms of charging this criminal conduct. So while the state said in the statutes, we want the unit of prosecution, on these cases to be one for each image. With sentencing, that's an entirely different animal. Now, the statute itself, this court has already stated in the case in the 90s, Wilkerson, that this statute was a codification of earlier cases, specifically Gray versus State and State versus Taylor, where the rationale for consecutive sentencing was to protect, and I'll quote from Gray, criminal activity that is so extensive and continues for such a period of time as to warrant consecutive sentencing. The rationale behind it, as related in Wilkerson, as stating that the legislator codified the intent with those cases to make sure that the thrust behind consecutive sentencing was to protect the public from people with an extensive history or an extended history of criminal activity.
How would you propose that we define extensive?
And that's the broader issue. Your Honors today are going to have to decide what approach to take in determining what what extensive means. And in the interim since 1989, and some of the cases that I've highlighted, one particular monster footnote in there, there are two approaches that courts take. One, they can either take the fact that in and of itself the number of charges can be considered enough for extensive criminal history, and the other one is a broader totality of the circumstances approach. And this is the approach that we argue that the court should adopt today.
But when you say totality of the circumstances, I mean, it can't be the totality of all circumstances. I mean, the circumstances have to relate to extensive, the term extensive. So that's what I'm trying to get at is, I mean, how are you interpreting extensive? What does that mean? And what circumstances do you think are most relevant to determining whether something is extensive?
So the guidance that we would request this court provide are not at all dissimilar and are taken from the cases that we cite in that footnote. These are factors that cases have relied on in determining what is considered extensive since over the past 20 years. The footnote that I cite has almost every court case that has cited one particular case in 1992, State versus Cummins, in reliance on either a bright line approach in saying 8 convictions or more is considered extensive, or these other courts which look more at the totality of the circumstances, which are the facts and circumstances of the particular case, which in Mr. Perry's case would be the fact that he was very young when this happened, the fact that he had no criminal history, the fact that
If I could interrupt you just for a moment. So I want to get at, I guess those factors to me don't seem all that relevant to determining whether something is extensive. I mean, if you look at a dictionary definition of extensive, you know, it's things like broad in geographic scope, or, you know, occurring over a period of time. And the defendant's age, to me, speaking only for myself, I mean, that doesn't seem particularly relevant to whether the the criminal record is extensive.
Correct, and that may be one factor in a litany of others, and there are others that we have cited in our brief, and they are geographic region, whether or not the person has continued this behavior over a long period of time, whether or not there are multiple victims involved. That's the kind of non-exhaustive list of factors that trial courts need to have at their disposal in order to make this decision. And I think that interpretation goes best with, number one, the broad discretion that's already afforded to trial courts, given the fact that they're in the best position to determine whether the person in front of them is someone from whom the public needs to be protected. And two, it gives the trial courts findings that they can place on the record and findings that the appellate courts can consider in terms of whether or not they abuse their discretion in terms of ordering the consecutive sentencing. In Mr. Perry's case, Mr. Perry had 2 9-year sentences run consecutively for these charges, and because of the nature of the statute, the state was able to enhance the penalty because anything over 25 images could become a Class B felony instead of a Class C, and it's to serve at 100% with absolutely no good time credit or relief. So we're looking at an 18-year sentence at 100% for someone who has no criminal record, for someone whom the pre-sentence report indicated the officer could not find. There were no victims in this case. Of course, the victim could be society at large for the nature of the images. For someone who graduated from high school, who held steady jobs, and had nothing else on his record other than underage drinking and marijuana smoking.
Well, there would be victims, they just weren't dead.
Correct, yeah. Yep, and as the court is well aware, you do not have to prove that the person was actually underage for this
Ms. Jones,
particular
excuse me,
offense.
you're not asking us to overrule Pollard, are you? Just
No.
carve out an exception from it? Is that what
No.
you're asking?
No, this is 100% in line with Pollard. So
Abuse of
Pollard-
discretion with presumption of reasonableness? Okay, go ahead and tell me why.
So Pollard applies for consecutive sentencing as long as the trial court puts reasons on the record. So in this case, the trial court did not put adequate reasons on the record. Now, we're arguing this in terms of the court takes the bright line approach that 25 or 24 convictions automatically, once it's set that standard at that number, that automatically qualifies somebody as an extensive criminal history, then that would be the end game. But if the totality of the circumstances approach remains, That gives the trial court the discretion that's contemplated in Pollard. The bright line approach does not. If a court wants to do something different, if the court, in this example, if the court had wanted not to do consecutive sentencing, but that bright line approach was in place, the trial court would have zero discretion in terms of being able to say, well, I know there are X number of images and X number of convictions, but he's had no prior criminal behavior. He's otherwise been an outstanding citizen. He complied with police. The bright line approach would shackle trial courts, in essence.
Well,
But, go ahead.
go ahead, Holly, that's fine.
Under the approach that you're advocating, would the trial judge have the ability to impose consecutive sentencing in a situation where somebody had no prior criminal activity that could be detected at all,
Absolutely.
but they had a gigantic spasm of it on a single day? Would consecutive sentencing still be an option under the totality of circumstances approach?
Absolutely.
Explain.
So there was a similar, the factual basis in Cummins is kind of similar to that. It's not in one particular day, but you had an individual in Cummins who did prescription fraud, got away with it over a number of months and a number of different pharmacies, 80 different counts that he was indicted under, but only pled guilty to 8. So very small number of convictions, but a very broad base of criminal history. Now, we're not arguing that the court this is an non-exhaustive list of factors. They don't necessarily have to find that one outweighs the other, but it is a balancing approach that the court would have, and would have a number of different things in its toolbox in order to determine the ultimate thing, which is the old sentencing standard of whether or not the sentence reasonably relates to what happened, or the criminal offenses that are being punished, and B, whether or not the behavior is bad enough or extensive enough that the public needs to be protected by consecutive sentencing. So those would still remain. So if something happened, if someone, the classic image that I can think of is if someone goes on a shooting spree in one day, and with the combination of violence, multiple victims, indiscriminate, perhaps if there was proof, indiscriminate acts of violence on people that they didn't know, that's absolutely something the public would need to be protected
But
from.
let's say it's one victim, one particular day, a truly horrific day for that one victim, no prior criminal activity, it's not over a long period of time, but, torturing, whatever, might be involved with a particular victim within a defined period of time. It's really one episode. Under your scenario, would the trial judge have the option of imposing consecutive sentencing?
If it was more than one conviction, they always have the option, because that's what 4035-115 contemplates, is multiple convictions. But the ultimate question would be if the trial court put those requisite findings on the record, and if they bore out in the proof that this was somebody, if it was extensive, that the public need to be protected from their activity, then absolutely. And I don't think you get that with the bright line approach, because if you said, well, at 10 it becomes extensive and you've only got 3, but they're absolutely horrible, then the trial court's kind of bound by that. So the totality of the circumstances approach that we're first advocating that this court adopt, and then second apply to Mr. Perry's case, gives the trial courts the freedom that they need and frankly are already entitled to under the law.
Ms. Jones, just
Yes,
to
Justice
interrupt
Gibbons.
for a second. You characterize the trial court's approach here as a bright line approach. And I'm wondering if you can just point to, what in the trial court's ruling you think is the best evidence of that. I mean, I just to tell you where I am, I see some evidence that, there were some other things considered. It wasn't just the number of convictions. So is it actually accurate to characterize what the trial court here did as a bright line approach?
There is a paragraph in volume 4, page 23 of the record, which I believe is a sentencing hearing, where the trial court says, I find that based on the number of convictions and based on the number of offenses he's committed and based on the number of conviction or charges that he's pled to, I find that his record to be extensive.
Let me ask the question I was about to ask, and you said he didn't make extensive findings. In the sentencing hearing, the trial court said, I also consider the fact that he not only possessed these, he means images, but apparently he shared and traded a lot of these child pornography videos and pictures with other individuals. Are you saying that's not correct?
That is not an inappropriate.
Are we getting back to Dropbox and how many people looked at it?
Partly. Number one, that's an element of the offense. And unless the trial court found that what he had done was so out of character or in excess of that, it's inappropriate to run consecutive for that. Two, the fact that he has, there are a couple things that need to be understood. First, and the state makes mention of it in its brief, 4 devices were accessed. That could be my cell phone, my computer, and it's important that that's understood. That is a device accessing it. And the state could have made proof. They could have gotten the proof that these individuals or he'd shared with these individuals, but it did not.
I guess this goes back to my, this just goes back to my earlier question about, why it matters, whether it was, one single act of downloading or more than one. I mean, would you acknowledge that a lot of harm can be inflicted by kind of one click of a mouse? I mean, imagine a situation where, someone is hacking a computer or, committing some sort of computer crime and, with the click of a mouse, financial information of thousands of individuals is stolen and used. I mean, that's the kind of thing that seems to me could fall within the definition of extensive, even if it's one click of the mouse.
And to that, I would say under any other statute, one click of the mouse could have been one conviction. And that is, there are 2 different things. What is extensive for purposes of charging somebody under those statutes was a determination that the legislature made in determining the unit of prosecution on those. It's an entirely different inquiry on extensive. So, for example, Mr. Perry admitted to sharing these in 2016 and 2017, which could have been December 31st, 2016 and January 1st, 2017. What we have from the proof, just the bare bones proof that the state did not go any further, is 2 individual trades. He could have traded to 2 people, and it's important to understand that on Dropbox, this isn't the file sharing programs like Napster or anything else that was in the past where you, in order to participate in the program, have to share everything with all these other people, and indiscriminate sharing goes on without someone having the control to determine who is taking or exchanging files with them. With Dropbox, he has to make those connections and he has to share them. So we have evidence in the record that the state at trial has put on the proof of 2 exchanges.
He has to share his password with the other person, right?
He would have had to have shared his password or have had to provide a link. So we have instances of 2 sharing, but under the statute, it's still, even if he's sharing that file of 174 images, they still all count as 174 potentially chargeable, individually chargeable felony offenses.
You mentioned that the 4 devices. Is there proof in the record that he accessed the 4 devices?
There is no proof in the record who the devices belong to, or to whom the devices belonged. And that's really the most compounding thing in this case. The state had, Mr. Perry was cooperative at all levels. The state had the opportunity to put on much more proof or to gather much more proof. And I'm not saying it's not possible that Mr. Perry could have been considered properly to have warranted extensive criminal behavior, extensive criminal convictions under this section. But the state just simply did not put enough proof on the record to show that Mr. Perry gets at what Gray and what the statute is intended to protect, which is protection of the public for people who are having a sustained criminal intent or a sustained criminal activity. And that's simply not the case here. You have a 19-year-old who is serving 9 years at 100%. This case, under the facts and under the proof that the state really didn't provide, just simply does not warrant a sentence of 18 years at 100%.
So what is the standard? Is it still abuse of discretion? You're asking us to find that the consecutive sentencing here was an abuse of the trial judge's discretion?
So this won't change anything in terms of appellate review, other than giving appellate courts more tools and the trial court more tools under which to examine a particular sentencing factor. It's clarifying for this particular factor, you need to look at X, Y, and Z. It's a non-exhaustive list. One doesn't have to be more important than the other. And ultimately, as long as the trial court puts reasonable findings and makes a correct or a non-erroneous assessment of the proof, it's going to be held up.
Well, let me go back to follow up on Justice Kirby's and Justice Page's earlier question with regard to Pollard. What is your position with regard to whether the trial court satisfied his obligations under Pollard in this case to where we should show deference to the decision?
Your Honor, we argue that this was an erroneous assessment of the proof. If the trial court had more proof at its disposal by the state at the trial court level, it could have made an appropriate finding. But what is in the record and the findings that the trial court made are simply not sustained by the proof. So it would be an erroneous assessment of the proof.
Well, is it erroneous in the sense of we should not show deference, it should be a de novo review by this court, or is it simply, it's in essence abuse of discretion because it was an error of law?
This should be, examining this under Pollard, the trial court did not do what it was supposed to do. There was an abuse of its discretion in ordering permissive consecutive sentencing, and this abuse was created under the assessment of the proof, which was the fact that Mr. Perry did not have an extensive criminal history. And when that happens, the review is it's either de novo or reverse and remand for another sentencing hearing. There's more than enough, there's more than enough for the court to make a determination on the record. The state chose not to put more proof on the record, so from what this court has available at its disposal in the record here, there's more than enough to make a de novo review and to find that concurrent sentencing is warranted on all these counts.
So just to clarify on the standard of review, so if the general abuse of discretion standard applies, is it your position that whether, I guess, the threshold, if you will, issue of whether the trial, when looking at the trial court's determination that the record of criminal activity here was extensive, that we should look to determine whether the trial court's decision on that was based on a clearly erroneous assessment of the evidence? Is that sort of the level at which we review that? We don't review that de novo to determine whether the trial court correctly made that determination?
The examination will first be under Pollard, and then finding that abuse of discretion, it will be a de novo review.
But we have to first find that determination that the record is extensive was based on a clearly erroneous assessment of the evidence.
Correct, Justice Campbell. And in order to do that, this court's have to settle the age-old question after Cummins of whether or not this is a bright line approach or a totality of the circumstances approach, or whether this court even wants to take an approach at all. I'm getting into my time, so I'll turn it over to State. Thank you very much.
May it please the court, Brent Cherry for the state. In considering the appropriate sentence in this case, the trial court found that this was certainly an extensive amount of criminal activity, emphasizing that 174 files is a large amount of child pornography. But the court also noted the defendant's chronic, quote, problem of looking at young girls, children, for sexual pleasure, unquote. The court recognized that.
Then what's the proof in the record that it was chronic, Mr. Cherry? Is it more than 2 times, as Ms. Jones said?
Well, Your Honor, I think I didn't find anything in the record that referred to 2 times. When the defendant told the investigators that he had a problem looking at essentially little girls, that evidences a chronic problem by his language.
Well,
and when we talk
he could have
about
had that problem 1 day or 2 days. It doesn't mean he had it for 2 years.
But, Your Honor, he did this over a period of time.
How do we
and
know
his
that?
record
How did the state prove that at trial?
There was an offer of proof, and remember, Your Honor, this was a guilty plea case. And in a guilty plea case, the state makes an offer of proof based on whatever evidence they collected.
But there was a sentencing hearing as well, correct?
There was a sentencing hearing
Well,
as
so
well.
there's an opportunity to put on proof at the sentencing hearing.
Yes, there is, Your Honor. There's also an opportunity by the defendant to say this is a one-time thing. He never said that.
But whose
the
burden is
evidence-
that?
The pre-sentence report indicated that in the defendant's statement, he told investigators that he had a problem looking at little girls, that he had downloaded these images, that he uploaded them, that he shared them, and also he had the report that indicated that at least that there were 4 particular IP addresses that had accessed the Dropbox account.
So did the state prove what these devices were? They could have all been his devices. I mean, was that not within, is that not something the state could have proven, who these devices belonged to?
They probably could have proven exactly who these devices
And they
belonged to,
could have
but Your
proven
Honor,
every single time he uploaded to Dropbox as well to show different dates and times, correct?
Your Honor, to be very honest, I think the uploading is something of a different issue, whether that was one time or a dozen times, but the downloading is 174 images, and each one of those downloads, each one of those images is a separate offense. So when we
Right.
talk about the extensive nature of his criminal activity, we're talking about 174 instances, and this was pretty heinous material. We're talking about infants, we're talking about preschoolers, we're talking about children that are subjected to abuse by adults, and they're staged in sexual conditions with other children. And when we talk about 174, I'll admit that the judge really focused primarily on the number of images and files.
And does it matter that could have been done with one click?
I don't think it really does, Your Honor. Now, in this case, there really is no evidence that this was done in a single click. That is total speculation.
But
by
again, that's the
defense.
state's burden to prove, is it not? So if that's the case, if it's speculation, then we would have to, it would be the state's problem.
Your Honor, the burden is on the state to establish by a preponderance of the evidence. The judge would have to find by a preponderance of the evidence that this was criminal activity that was extensive in nature. And by a preponderance of the evidence, when the defendant admits that he has a problem that's ongoing, when he admits this happened over a period of years, when he
Okay, I
admits
want to drill down on that. What's in the record? He said that he lived with his grandparents during 2016 and 2017. What are you relying on to say that the images were downloaded over a period of time? I want to know exactly what that is.
Well, Your Honor, what we have in the record is the defendant's statement that this happened when he lived with his grandparents in 2016 and 2017. And the judge noted that this was in 2016 and 2017 that this happened. So it's true that we don't have a lot of information, a lot of detailed information.
So
but
that's it?
That's
We
it.
have,
Is that in
that's
the
all we
factual
have?
That's the
proffer?
length of time, yes, Your Honor.
And that's in the factual proffer?
Yes, Your Honor.
And that was, the factual proffer was before the court is sentencing. The court's required to consider what happened at the
It's the plea hearing.
at the plea hearing,
Was
right?
it the factual
Sentencing.
proffer, or was it the pre-sentence report?
It was both, Your Honor.
Okay.
When the state presented this, they presented the proffer as this happened in 2016 and 2017 when he lived with his grandparents in Madison County. So they were establishing both the jurisdiction and the offense itself.
Would the state's investigation not have shown the date and times of the downloads? I mean, that's basic computer information they would have had, would they not?
Yes, Your Honor, they would have had,
So I wonder why they
Maybe-
didn't put that
maybe-
into evidence if they're seeking extensive criminal history finding.
well, Your Honor, first of all, as far as the downloads are concerned, and this is reading a little bit in between the lines here, this whole investigation began when Dropbox made a report of these 174 images that had been uploaded. Just by the nature of this kind of a case, this would have to have been downloaded before it was uploaded. Whatever device that was used, whether it was that evidence was destroyed or lost, we don't know. But we do know that the defendant admitted that he downloaded this material and then uploaded it and then shared it with other individuals.
How does
So-
the state, oh, sorry, did someone else have a? How does the state interpret extensive? And what's your position on what factors are relevant in determining whether a criminal record is extensive?
Well, Your Honor, that's kind of at the foundation of this whole problem. We don't have much of a definition out there in the case law of what extensive means. When we look at the dictionary, extensive means having wide or considerable extent, or widely extended in space, time, or scope, great or wide, or capable of being extended. So that's a little bit perhaps broad, we could say. And when we look at these cases, how much discretion do we want to give the court to determine what is extensive? Do we want to put limitations on the court, or do we want to keep it broad? When we look at that old case, 1976, Gray versus State, the defense in that case wanted the court to look at the offenses. That was a robbery case. A guy went in, and there were 2 victims in this robbery, and the court wanted to run these sentences consecutively. And in that case, the defense wanted the court to limit this consecutive sentencing based on a single criminal episode. And the court in Gray said, no, we reject that altogether, and went on to lay out some things to consider, which were the precursor to the statute that we have now. But do we want to put a limitation of the trial court such that they cannot consider a number of different factors in various circumstances?
Let me go back to, rather than saying, do we want to do it, go back to Justice Campbell's question. How does the state define extensive?
Your Honor, I think if we want to look at things to consider in determining extensive, in accordance with Wilkerson, we don't want to have a rigid formula for determining what's extensive, but there are things to consider, and I would lay out a few of those for the court.
Please.
First of all, I think it was proper, as in this case, for the court to consider the number of offenses, the number of criminal acts that were involved in this case. And we could go to criminal acts in other cases as well to determine this defendant has a criminal history that is composed of extensive activity. But under Cummings, the whole basis of Cummings is it can be what we have in this case alone. It doesn't have to go beyond this case to
Cummings'
determine that.
analysis, you will concede, was succinct, shall we say?
Yes, Your Honor.
Okay.
Yes.
So, all right, so you have number of offenses.
Yes,
What
Your
else
Honor.
goes into the definition of extensive?
In all fairness, Your Honor, I think we should and could consider an element of time, but that should not be a limiting factor. For example, let's take a different type of case, just as an example. Let's say a person releases a poison gas that spreads throughout a community and affects 100 or a couple hundred or 1,000 people. Would that be considered extensive criminal activity? I think it properly could be. A person who sets off a bomb certainly could be considered
So
criminal,
are you
extensive
getting
criminal
at
activity.
number of victims? What do you?
Yes, Your Honor.
Okay, number of
Definitely.
victims. What else?
I think it could be the type of activity and how that type of activity could spread and build upon itself and multiply itself. As in this case, putting out these images and these files in an atmosphere where they're shared and then shared again and shared again, and that harm is multiplied.
Should we,
Doubled over and
Are
over
we
again.
speculating as to that? Is that what the state need to prove?
I'm sorry, Your
Would
Honor?
the state, though, not need to prove that these images were shared and then shared and then?
Well, that they did
shared
prove
around the
that, Your
world?
Honor. But first of all, the defendant testified, or not testified, but rather told investigators that he shared and traded these images and files. And second of all, we have the evidence from the Dropbox material where 4 different IP addresses access it. And the whole argument, well, he could have had 4 different devices. That just really doesn't,
I've
that's
got
not a
4
reasonable
devices I
argument,
could
Your
do
Honor.
that with.
I mean,
I've got 4 devices I could do that with. Why?
I do too.
well, you could, Your Honor, definitely, but would you? And why would you? Why would you go and do this on 4 different occasions? As a
Yeah.
19-year-old, are you going to have 4 different cell phones, 4 different devices that you're using to do
You
this?
got a cell phone, you got an iPad,
Laptop.
you got a laptop, you got one other device, I mean, that's not,
But I guess it
Well-
just points how we're speculating as to what could have happened, and we really can't speculate
But, Your Honor,
for the
by-
benefit of the state, I don't think.
But by preponderance of the evidence, could the court determine that this was extensive? And we're only talking about the preponderance of the evidence. That's
Well-
the standard for the court to determine this.
Mr. Cherry, going to Ms. Jones' point of, do we say there's a bright line rule, or do we adopt a totality of circumstances?
Well, Your Honor,
Test, it sounds to me like you're agreeing it should be a totality of circumstances test.
Well, I really don't think there is a bright line rule out there. Cummings had 8 crimes. We have 174 in this case. Really, are we talking about a bright line standard? Definitely not. But when we look at the totality of the circumstances, I think it would be improper to go too far. For example, when we're talking about the extensive nature of the criminal activity, it should be limited to the criminal activity. Whether the perpetrator is 18 years old or 80 years old really is not relevant to the extensive nature of the criminal activity. But the type of activity, how far spread the activity is, how many victims are impacted, the nature of the impact. And again, when we look at child pornography cases and the damage that's done to these kids, it's pretty horrible. When we talk about 174 images, just to put this in a little bit of perspective, I rode a school bus when I was a child in rural Idaho. I remember as a young child getting on the bus and looking over the top of the door, it said maximum capacity, 66 passengers. So when we're talking about 74 files, or 174 files, some of these files involve more than one child. Some of the children were staged in situations sexualizing each other. We're talking about essentially 3 full bus loads of children. My first grade class in school was 30 kids. We're talking about the first and second grade combined.
I mean, there's no doubt it's a horrible crime and it should be punished. But what if it had been 1 click and 10 images? Would that have been extensive criminal conduct in your mind?
Well, Your Honor, that makes it a little bit tougher call with the
And
court.
Where's the line? If it's under 100, over 100, where does that?
Your Honor,
where does that
again,
fall?
I would really hesitate to draw a bright line. If there is any kind of a bright line standard here, I think we could look at the legislature's drafting of these statutes. 25 or more constitutes a B felony. So we're talking about 26. In this case, we had 6 B felonies, 26 images in each one. We got 154 of the images, and then another 18 that were charged individually, bringing us up to the 174 files.
So you would agree that the trial court should not simply rely on the number of images as the sole basis for imposing consecutive sentences?
Well, Your Honor, honestly, I think the trial court could rely solely on the number of images when there are so many. This is such an extensive range of crimes and victims that, and that's why I hesitate to really set a hard standard where all elements are required, because some elements, when they're so strong, would overpower the need to have other elements.
Are you-
So-
are-
Here we've got,
oh, go ahead.
Are you asking us to look at the nature of the crime itself when we're determining whether criminal activity is extensive?
well, in a case like this where you've got so many victims, I think the number of victims and the type of crime where it's proliferated and continued because of its nature of going out on the airspace and one of the things that I pointed
But
out.
the legislature's already made a decision to make 25 images a B felony and take it up to 12 years punishment at 100%, right?
Yes, Your
I
Honor.
mean, this defendant could have been sentenced to a lot more time than he actually got.
Yes, sir. Yes, Your Honor, he could have been. And the court in this case chose to only run consecutive sentences for 2 offenses, where he could have ordered 6 to run consecutive, plus we could throw in the other 18 as individual sentences.
Let me follow up. I want to be able to define where you disagree with defendant's counsel. It sounds as though the basic test that you would apply is very similar, and you agree that the word extensive indicates breadth of some type. So the basic test, as you would put it, is not unlike the totality of the circumstances approach that is advocated in the defendant's brief. but you would give the trial court wide latitude to impose consecutive sentencing based only on the number of offenses.
I think that's a fair assessment, yes, Your Honor.
Okay.
Can I, let me ask you a little bit about the standard of review. Ms. Jones said that here, the standard under which we would review the trial court's initial determination that this record of criminal activity is extensive would be within the abuse of discretion framework. We would determine whether that determination was based on a clearly erroneous assessment of the evidence. Do you agree with that?
Well, Your Honor, it's funny because I wrote down the standard of review just in very precise terms so that we could talk about this. And when we look at the standard of review, it's abuse of discretion with a presumption of reasonableness. That's under Pollard. The trial court abuses its discretion when it applies an incorrect legal standard, reaches an illogical conclusion, bases its decision on a clearly erroneous assessment of the evidence, or employs reasoning that causes an injustice to the party complaining. And when we look at the assessment of the evidence, I think it's hard to argue in this case, I would suggest, that the trial court erroneously assessed the evidence. We looked at everything that was brought before the court, everything that the defendant admitted to. We looked at the images, the types of images, the number of images. We looked at the time frame. Under all these, the court's determination that this was extensive criminal activity is well-founded in fact, and well-founded in his assessment of the evidence. And he laid that out all on the record. With that, I would suggest that it's very difficult to find that the court abused its discretion in this case.
And so you would agree with how Ms. Jones articulated the standard of review?
I think the way it's been articulated in the past, and I think her articulation of the standard of review is basically correct. But I would disagree that this was an erroneous assessment of the evidence.
And is there, as I understand the parties' arguments, there doesn't seem to be really a dispute about whether it is appropriate to take into account the convictions currently before the court in determining whether a record of criminal activity is extensive. Is that your understanding as well?
Yes, Your Honor, I think that's pretty clear under Cummings. That's basically what Cummings was laying out.
Okay. Thank you.
And would it not be appropriate to consider this defendant's age in terms of being 19, not, brain development, lack of impulse control, et cetera, all those factors we consider in juvenile sentencing, in addition that he had a steady work history, that he had no other criminal involvement? Wouldn't that all factor into whether there's an extensive criminal record?
Well, Your Honor, as you read the record, all this was presented before Judge Allen, and so he had a chance to weigh and measure this. But when we get to the issue of consecutive sentencing, his role was to determine whether criminal activity was extensive, which really doesn't bring into play the age or the experience of the defendant. That certainly would have been considered in the overall determination of an appropriate sentence. But that's something that, again, is subject to the discretion of the trial court.
So, in the trial court's findings as to whether his assessment of the record was clearly erroneous, says, I also consider the fact that he not only possessed these, but apparently he shared and traded a lot of these videos and pictures with other individuals. Does the record actually establish that?
Well, Your Honor, the defendant admitted that he shared and traded these images. That's the primary focus. When he spoke to investigators, he told them that he had done that.
You're talking about the pre-sentence report?
The pre-sentence report and the proffer at the guilty plea hearing. And then additionally, we have the pre-sentence report that includes the report from Dropbox indicating that there were 4 IP addresses that accessed this Dropbox.
Which we've said we have not been identified. So you're basing it only on the defendant's statement that he shared and traded?
Yeah, and Your Honor, again, I would return again to the report with Dropbox, because even though we don't know exactly what those IP addresses pertain to, I would suggest that if these were solely the defendant accessing these, he could have said so. And it's
So we're
for the court to determine that by preponderance of the evidence.
We're talking about a pre-sentence report. We're talking about a proffer of evidence at the guilty plea hearing, which is done by the attorney for the defendant, and the defendant just stands there most of the time. Was there a written confession that's in this record?
Not in this record, no, Your Honor. But again, I would point out to the court that at the end of that proffer, the judge turns to the defendant and
That's
says,
right,
is
yeah.
this substantially correct? Do you have any objections to this? And there was no objection.
And he said yes.
They said yes, yes, Your
Okay.
Honor.
So, going back to a question you were asked earlier, how would you define extensive criminal record? And I know that it's a broad definition, but if you were writing this opinion, how would you write out, this is what we mean by extensive criminal record?
Well, Your Honor, I think if we really wanted to go into the bushes about what his record of criminal activity would have been, we would include every one of these 174 images, first of all. We would indicate that this was something that happened over a period of time, 2017 and 2018, by the words of the defendant. We would include that he shared these images with other persons. And we would also, in this case, and I'll add this in, although this is something that I don't think is all that terribly pertinent in this case, but when we talk about a record of extensive criminal activity, we could always also look at the underage alcohol use and the marijuana use.
Come
Really?
on,
and
come on.
that is criminal activity, but I'm not
That
relying on
is,
that
you gotta
for-
admit, that is weak tea.
And I
mean,
would admit that, Your Honor.
yeah,
Yes,
you
and
need to
that's why I
just
did not
punch the
make that a
number
big
of
deal.
offenses and kind of put that to one side.
And I don't want to make a big deal, in all honesty, Your Honor.
Okay.
But that is criminal activity. That was
he
considered
prosecuted
more
for that?
when we...
Was he prosecuted?
No, Your Honor. And that's something that was considered when we were talking about the individual length of the sentences. The judge looked at that. But, honestly, not a big deal when we're talking about criminal activity for extensive criminal activity for consecutive sentencing. And so you're exactly right, Justice Kirby, when we talked
Let's
about
just
this
put
case.
that to one side.
Yeah,
So-
it's
so-
not a big deal.
I was waiting
Again,
on you to bring that up. I knew you couldn't
we
hold
have-
it back.
We have kids who have gone through college and,
yes.
just don't want to go there.
I've got
But
kids.
there are no
I've
personal
been a kid.
admissions up here, no personal admissions.
But really, in this case, we're talking about the 174 images. That's the
Gotcha.
big piece of cake when we're talking about this case and how long it happened, how many victims there were, and how extensive this reaches in today's internet age.
So you're not asking us to draw a line, you're just asking us to say that there's enough in this record to be over the line.
Yes, Your Honor, and allow the court's discretion to figure this out. That's why they get paid the big bucks. No other questions? Again, I would encourage the court to affirm the judgment of the trial court in this case.
Thank you.
To the extent that the 4 devices issue is relevant, your best case scenario is the 4 devices were your own clients, correct?
Yes, and
Okay.
again,
Well, then by definition, aren't there at least 4 instances in which he's clearly accessed those files as
He-
opposed to 2?
he's accessed them.
Yes.
Which is
But you
not
said
enough.
earlier that the evidence showed a minimum of 2. But doesn't the evidence actually show a minimum of 4? I mean, a minimum of at least 4.
Minimum of 4 different times
Yeah.
that someone has accessed that, but an admission by Mr. Perry that he has only completed the element necessary for this particular offense, which is also exchanged or traded 2 different times.
So, counsel listed 3 different considerations in determining extensive criminal record. What factors would you add to that list?
I will just iterate the ones that that have already borne out in the case law that I've provided on the footnote in pages 20 through 22. The time span, and counsel for state is correct, single act or single offense is not appropriate. I will add also that this court has spoken that it does not matter if it's a felony or a misdemeanor. Court looks at that, and I believe this case, the Supreme Court case was Dixon, that stated that the statute didn't specify whether, it didn't distinguish between felonies and misdemeanors. And to Justice Campbell's point, Cummins and all the case law has borne out that they can consider just the instant offenses before the sentencing court to find and sustain a conviction for consecutive sentencing.
Are there any factors that you think are more important than others in determining whether the record of criminal activity is extensive?
Yes. And to get to the state's point about, and Justice Kirby and Justice Lee's questions about providing a definition for extensive, the state has, the legislature has stated that extensive history, the purpose behind this is to protect the public and to protect people from a time span of conduct. I think time is one of the most important. Whether or not this person has shown a sustained inability to conform his or her behavior to the confines of the law. That indicates not only ability to be rehabilitated, but respect for the law, respect for others, respect for the public. In this case,
sorry to interrupt. You said the legislature has made that clear. What's the source of the time? It's focused on time.
Yes. So the case that I mentioned earlier, Wilkerson, stated that the 1989 codification of those two old cases, Gray and Taylor, the 1976 case, was essentially a codification of the intent behind those, which was to protect the public from people who had extensive criminal behavior and over a particular amount of time, such that it warranted protection from the public.
Does the statute mention time?
The comments to the statute mention that reference to Gray and to that specific finding in Gray. So it doesn't specifically say it, but the statement from the Wilkerson case, the Tennessee Supreme Court case, Wilkerson case, as well as the advisory or the comments that are in that statute, heavily lean toward that. And then facts and circumstances of the case is kind of like the catch-all factor that a trial court would have in terms of anything else. In Mr. Perry's case, I know Justice Campbell did not want to look, but the age, a court could consider that. Doesn't necessarily need to be dispositive, but everything in this is
age more
designed.
appropriate in consideration of the length of the sentence for each count?
Correct. Now,
As opposed to consideration for consecutive sentencing?
It could, and for example, you could have somebody who was 20 years old, but in the span of turning the age of 18 and 20 had 6 criminal offenses, which in the Wise case that was overturned recently, within the last year or two by the Court of Criminal Appeals, that might be an extensive period of time for someone who has just reached the age of majority, whereas somebody else, 6 offenses over a span of 10 or more years might not necessarily be something that would be extensive, but it would afford the court the discretion to make that call. If that's a person that's been in their community, that they've had before, that they know is a known quantity, or that the public is not safe as long as that person is not in custody. And I will just reiterate the fact that the proffer for the factual basis for the entry of the guilty plea would not change whether or not he would still have been able to be charged with the number of convictions or pleaded guilty to the number of convictions he had, whether or not he had traded with more people. This is still 174 images to which he's admitted to trading. It could have been all downloaded with a single click. It could have been just the 2 people. But we don't know, and the court did not know at trial. And that's the bright line. The definition in Black's dictionary for the bright line approach is it sometimes sacrifices equity for clarity, and I think that's a little bit of what we have in this case, that there has been some filling in the gaps where the state had the burden of proof, not beyond a reasonable doubt, but just preponderance of the evidence to get to that, and it did not do that.
Mr. Cherry pointed out here that, that this was 174 images. Many of the images contained more than one, images of more than one child. So if you look at, I mean, perhaps I'd be interested in your response to what we know about that. But I guess give me your best argument as to why just the number of victims, when you have an image, the number of images that is this large is not in and of itself extensive.
It could be, but the fact is that the images were not made part of the record, so this could have all been the same person. There was no indication in the record of what the content it was. They're just going by the file names. There's nothing indicating that this wasn't 174 images of one child. Now, if it had been 174 images of 174 different children, the trial court could have considered that, but it didn't have that proof before it. You can't just lay the boots to someone just because of the offense that they've pleaded to.
So it's your position that it wouldn't have been a reasonable inference that if there's 174 images, that wouldn't have involved at least a significant number of child victims?
Not to sustain a difference between 9 years at 100% and 18 years at 100%. It's got to have something more than that. It's got to show that there is the difference between one victim and 174 victims is vast. And the fact remains that depending on how the state chose to indict in this case, if it's over 25 images, as it was in this case, the state could have charged Mr. Perry with a single count of a Class B felony and taken advantage of that enhancement from a C to a B, but it did not. The number of convictions and number of charges that we have here that he was indicted are solely a function of how it it was 100% within its discretion to charge that way. But
Thank you, Ms. Jones. Your time is up.
thank you, Your Honors. We just ask the court to reverse the decision of the Court of Criminal Appeals.
All right, we'll adjourn court in just a moment until 9 o'clock tomorrow morning in Nashville. We will start again. Mr. Hibner?